Supreme Court of Florida is now in session. Please continue.
Okay, the next case on the calendar is it Koo or Ko? Koo versus State.
Thank you, Mr. Chief Justice, and may it please the court. I'm Gray Thomas, here representing the petitioner, Leonard Koo, and I've asked to reserve 5 minutes of my time. Mr. Koo was convicted of committing burglary of a storage unit and becoming armed in the process, primarily based on the testimony of his employer and alleged victim, Dr. Soleil. After trial, but before sentencing, before judgment, Dr. Soleil wrote to the trial court, changing his story on some points that are very material to the theories of defense regarding lack of intent, consent to enter, and necessity.
Well, where's that in the letter? Where? Because I read the letter and I read what you argue, and it just seems like to me that the letter, it's clear from the letter he's sorry that the defendant got sentenced to 10 years. And he kind of wished this would all go away. But on the critical facts with respect, the facts on which the conviction had to be based, I don't see that he says anything that takes those facts away. Tell me why I'm wrong.
Your Honor, there are 3 key facts, and I think that's one of the things that got the trial court and the First District majority hung up, was they got hung up on what I would concede is a lot of opinion in the letter, a lot of regret. The key facts are he had keys to every dwelling. That's stated in the letter.
Okay,
and
on that, I'll let you go on after you answer this. The burglary here is not the burglary of a dwelling. It is a burglary of a storage unit. And he obviously didn't have a key to that because he broke the lock off. So I don't understand how that point that you're making has anything to do with the conviction in this case.
Well, a couple of points specifically to that question, Justice Kennedy. Mr. Koo clearly had knowledge of the access code to get into the building in the first case, in the first place, and his testimony at trial was he forgot to bring the key with him to the storage unit, that he indeed had one. Dr. Soleil testified at trial at pages 183 to 184 of volume 3 of the record that Mr. Koo didn't have keys or access to anything, any of his properties, period, except he claimed that Mr. Koo stole keys on one occasion, and then immediately thereafter when asked, "Are you saying he stole keys?" "Oh, probably. I wouldn't put it past him." Well, who knows what that trial testimony ultimately means. He also contradicts his trial testimony in 2 other respects that are significant to what was in Mr. Koo's mind, as well as to the issue of consent, authority to enter Dr. Soleil's various premises. One, the letter does say that his irritation was intense and frightening at times. During trial at page 185 of the volume 3 of the record, he denies that he ever got mad at Mr. Koo or around him. At trial, he portrayed Mr. Koo as only working for him on and off for a period of time, and in the letter, he makes it clear that he has known Mr. Koo for a period of years and that Mr. Koo has worked with him on a continuous basis. So he's changing the whole perspective about Mr. Koo's relationship with him. He does acknowledge that Mr. Koo lived under the same roof in the same house. He does acknowledge that he ran errands to his properties, but what he has done in his letter in those 3 material respects is to absolutely contradict his own trial testimony and corroborate Mr. Koo's.
Well, I'm looking at Judge Makar's dissent in this First District. The defense was one of the defenses was that the doctor had effectively given him consent. So consent was an issue. So and he denied that he had given him consent at the
Yes.
trial. Second, he had asserted a necessity defense, claiming it was necessary to keep the firearms out of the doctor's hands. When the doctor was asked about that, about what he had said about threatening to harm his own wife, did he deny what he had told the defendant? In other words, was there a contradiction on that issue at trial too?
The specific testimony from Mr. Koo was not flatly contradicted by Dr. Soleil at trial, other than Dr. Soleil denied being this person who was explosive in his temper and frightening. The letter does say that he told Mr. Koo, make sure I don't do something I'll regret.
Now, was he asked about that at trial?
He was not, that I
So
find.
we're really at a point, and this is there hasn't been an evidentiary hearing on whether this would qualify as the likelihood of acquittal, correct? You're just asking for an evidentiary hearing.
Yeah, I
want to make sure about that. We're not saying this entitles you to a new trial.
I don't think the case law forecloses the possibility that something could be so strong as to warrant a new trial on evidence such as this.
No, we would never grant it on a letter that hasn't been tested.
No, but I think there is no doubt that all of this needed to be fleshed out at an evidentiary hearing. This court's precedents and those of the other districts are very clear that if you're having doubts about the credibility of a post-trial recantation, you need a hearing. And that's why Dr. Soleil
Why didn't you bring a witness to this hearing? Wasn't this a hearing where evidence could have been submitted? You weren't precluded from that, were you?
Well, here's the unusual thing that happened is in at least two or three places with case law support in the written amended motion for a new trial, defense counsel indeed did ask for an evidentiary hearing, said it was required and justified. Dr. Soleil did not appear at that hearing.
Why not?
That's what I can't answer, Your Honor.
Well, that seems to be a problem from your perspective.
Well, I don't...
And furthermore, we have just a letter. This is not even a sworn statement. Isn't that also a problem?
No. There are the cases that I have cited, Your Honor, include any number of cases where there was one case, for instance, in which an evidentiary hearing was required, where bear with me for my list. I apologize for fumbling. Where there was a mere representation in a sworn post-conviction motion that the witness recanted to a third person. There was one of the first district cases involves a claim of recantation that was represented in a sworn motion, but it was based only on a videotape of the purported victims of an offense that the court in its decision said appears to have been made under suspicious circumstances that may have been very suggestive to those witnesses of what they ought to be doing and why. The court below, got also hung up with the position that these facts were known to the parties at the time of trial, therefore it couldn't be newly discovered evidence. That's not the standard. That's not the standard from this court in Archer. It's not the standard from the 4th District in Kendrick. It's a matter of whether you can prove by evidence other than from the defendant's own mouth that the witness is lying at the time of trial. And that's what these 3 points, key points in the letter do. They show that Dr. Soleil's position during and after trial changed in material respects.
Well, I don't see how it changed in the critical respect of concerning whether the defendant had permission to go knock the lock off the storage unit and take the guns and sell at least one of them.
Your Honor,
There's nothing that changes any of that in that letter.
Your Honor, but that's also why an evidentiary hearing is critical. Dr. Soleil, what did you mean by don't let me make sure I don't do something I'll later regret? What did you mean when you say that he had keys to every dwelling? Did you mean that to be limited to actual residential properties when you had various types?
Well, a storage unit is not a dwelling. I mean, that's
I know it's not, and Dr. Soleil is not a lawyer.
Well, he's a psychiatrist, isn't he?
He was.
Well, what can I say?
The point is, though, that these points are not inherently incredible. They're not obviously immaterial. They're not simply a spouting of information that's nothing new to the case.
It seems to me that the letter is sort of buyer's remorse.
Pardon me?
Sort of buyer's remorse that, oh my gosh, I didn't think he'd get 10 years. That's what this letter seems to be about. And oh my gosh, I know his family, and if he has to serve 10 years, his parents might be still around that long. And I mean, this is a letter of just, it seems to me it doesn't really go to the heart of the case. It goes to, I'm sorry he got 10 years.
That's why you've got to find the facts and not get hung up, as the majority below did, on the statements that are of remorse and opinion that are in this letter. You know, Dr. Soleil saying,
Tell me exactly what it is in this letter that would negate any element of the crime that he was convicted of.
The keys to every dwelling goes to intent. It goes to consent.
The keys to every dwelling goes to consent of breaking a lock, as Justice Kennedy said, on a storage unit?
That depends on the scope of Mr. Ku's authority that was given by Dr. Soleil.
Didn't he say he didn't give him the authority to go into the storage unit alone?
Pardon me?
Wasn't the testimony that he did not give him the authority to go into the storage units without him?
Dr. Soleil testified to that at trial. What would he testify to at an evidentiary hearing after trial is the more important point.
Well, this letter doesn't say that was different.
No, and we had somebody who is writing a letter. They're not being examined by a questioner or questioners who know what points they want to try to really find out to get to the truth of what Dr. Soleil is saying.
But this is the document you're relying on in answer to Justice Quince's question. Where in this letter is anything that negates the elements of the crime? Where is it?
There is no one thing that hits the home run.
Where is anything that you can rely on? Where is it?
The access to keys.
Where is that? We got the letter right here. Where is it?
He had keys to every.
He had keys to every dwelling. It's in the second line of the last paragraph on the first page, which is page 84 of the record.
And that negates what element of
That suggests that Mr.
No, what element of the offense does that negate?
That he didn't have permission to enter. It's relevant. It's relevant to that.
I thought you, and just so we make sure, when we deal with recantations, of course, we have these in death penalty cases. The question is impeachment, and I thought you said in his testimony at trial he denied. What did he say about whether the defendant had keys to his dwellings? Did he talk about that?
He said he did not have it, and this is at page 183 to 184, volume 3 of the record, when Dr. Soleil in trial testified, no, Mr. Ku didn't have keys to anything.
Okay, so it impeaches him on that, and that's up to then it's a credibility issue about his truthfulness. I mean, is that correct?
Yes, but it's more than what the courts have sometimes referred to as mere impeachment. It is a source external to the defendant, showing that this witness was not telling the truth at the time of trial. And that's the standard in Archer and Kendrick and that line of cases.
So his defense at trial was that I had access to this and I had the right to go in and take it and sell anything I wanted to.
Not to sell. The defense at trial, Dr. Soleil testified that Mr. Koo told him that he had sold one of the firearms. Mr. Koo's testimony at trial was that he stashed these guns, as they were called, at a lumber yard with some friends, and when he went to retrieve them the next day, the .22 was gone, and he doesn't know what happened to it. So that just goes to the issue of, of Dr. Soleil at trial indicating that there was a profit motive to make money from selling stolen property, which is nowhere else supported in the record.
And let me, the defendant testified at trial?
Yes.
Testified that he had become concerned that the doctor was going through a vicious divorce, and that he was concerned he might either harm himself or his wife. Did he testify to that?
Himself, his wife, or
okay, so what did the doctor testify to at trial concerning whether he ever had that conversation with the defendant? Did he admit that he had that conversation?
He was not, unfortunately, asked at trial about this statement that now appears in the letter through prescience that that I would say the defense couldn't have known he would make later, to make sure I don't do something I might regret. But the letter does demonstrate that he had the explosive temper and could appear threatening and frightening to others when he was going through his emotional turmoil during his divorce and custody case.
So it would have corroborated his defense of necessity?
Yes.
Defendant's necessity.
Just because you have keys to a place doesn't mean that you have the right to take stuff out of there, right?
Right. Of course, it depends on the circumstances. If I have a housekeeper with keys to my house, I certainly don't expect her to take my jewelry when she leaves. And so, I would certainly acknowledge that. The issue comes on the issue of whether Mr. Koo reasonably believed that he had to get these guns away from Dr. Soleil temporarily for the protection of Dr. Soleil and others.
Well, wouldn't that have been brought out as a defense? How could any of this possibly be brought out now as compared to when the trial took place originally?
Because Dr. Soleil was testifying very differently at the time of trial than what he wrote in his letter.
What did he testify at trial at? What did he say?
Testified at trial that he never had an explosive temper around Mr. Koo, that he never displayed any of those emotions. He testified Mr. Koo didn't have keys to anything. He testified that Mr. Koo was only an on and off employee, as opposed to somebody who was there on the ground, even living at the property where Dr. Soleil lived and had his primary office. So the whole issues of what Mr. Koo's access was to whatever properties, the relationship that he and Dr. Soleil had, the trust or confidence factor, the authority that Mr. Koo reasonably could have felt that he had to take appropriate action such as this. Mr. Koo at trial testified that there were some dresses that Dr. Soleil said, feel free to take those out of the storage unit. They belong to my wife. She's never going to wear them anyway.
This defense, though, of necessity strikes me as rather far-fetched. And particularly when there's a circumstance involving the sale to a third party of one of the guns. I'm having trouble understanding how the facts here, including any facts that might be supported by this letter, would support a defense of the legal defense of necessity.
Well, I think, and the issue of selling the gun, Mr. Koo did not say that when he was being interrogated by Detective Shacklett. He did not testify to that during trial. Dr. Soleil testified at the time of trial that Mr. Koo told him that at the time the guns were being returned, the other two guns were being returned. But the issue really, I
He
think...
got $300 to buy it back, didn't he, from the doctor? But that was
According to Dr. Soleil. And one of the reasons why the trial court found the letter not to be terribly credible was because, and Judge Daniel said this explicitly, was because I don't find Dr. Soleil credible, including during his trial testimony. So he actually flipped the analysis. You've got to analyze the credibility of the recantation evidence, which is going to require an evidentiary hearing.
Your time is up, sir.
Thank you.
Flies when you're having fun.
Good morning. Matthew Pavis on behalf of the state. The letter here was not a recantation, and that really solves this issue right off the bat. Justice Quince, you nailed it on the head. This is buyer's remorse. And Justice Kennedy, I think you were picking up on this too. It seems like he's upset after the trial that, wait a second, he's getting 10 years when he was just trying to protect me from my own self. But he never said he had consent to take the guns. And because this is not a recantation, it's not new evidence, and there's really no conflict for this court to even review to begin with.
Well, I think isn't the part, they say in their opinion that because you could have known this at the time of trial, it's not newly discovered. That's not correct. I mean, all the time, and we get this a lot in death penalty cases, somebody, for whatever reason, changes something they've said, and it may be a direct or it may be impeachment, and we at least give them an evidentiary hearing. We don't say, well, you should have known he was going to change his testimony, and then it's up to the judge to evaluate the credibility, and we say, recantations are viewed highly skeptically. But is that the statement of the law in the first district opinion about that it's not even, doesn't qualify as newly discovered evidence because it could have been known? Is that a correct statement of the law?
Well, really what the first DCA says
I'm just asking, is that statement correct?
In this case, yes, because it did come out at trial, and this is the weirdest part about this case factually,
Wait. She asked you about what's in the letter.
Yes, Your Honor.
Not what came out at trial, but is what came out in the letter. Could you please answer that question?
Is what's in the letter
newly discovered? That's what you all were talking about.
Yeah. And it is not newly discovered evidence.
The question was asked.
It is not newly discovered evidence, and the basis for that would be because of what was at trial. The defendant on page 267 of the third volume of the record said he did not have consent to take these guns. So this letter doesn't change anything.
Well, that's not because that he knew about it. You're confusing the substance with when this thing comes forward and the statement of the first DCA. I find it very disingenuous for you to stand there and argue that a letter that did not exist at the time of the trial is not newly discovered evidence because a party knew about it. It's impossible to know about something that's not created until after the fact. Isn't that true?
That is correct, Your
Okay,
Honor.
that's fine.
And
that's fine. We're where we need to be.
Yes.
So go ahead and argue the substance, but
yes, Your Honor.
that's not her question.
And I apologize. And really what it is, it's that one sentence in the first DCA's opinion that Judge Makar actually had a problem with on the motion for rehearing, citing that sentence saying, wait a second, this can't be right. He needs to have an evidentiary hearing on this because, as this court's decision in Archer even highlights, whether or not this would be newly discovered, you can't say that because he could have known about it at the time.
Here's the other part, though, about this, and I may have a different view than my colleagues. The credibility of the key complaining witness is at stake. He, unless I'm understanding, when the victim was asked, did he have keys to other, your dwellings? No, he didn't have that. No, he never lived with me. He said, but here in the letter he says he had keys to every dwelling. Now I realize that he doesn't have keys to the storage unit, but if I'm a juror listening to that, and I understand this is someone that lives with has lived with the person, it changes what the relationship is. So why isn't that impeachment to allow the trial judge to evaluate what, in an evidentiary hearing setting, what was the relationship between the two of them? And on the necessity, was this defendant legitimately concerned about violence because he had guns there that he might use either on himself, his wife, or somebody else, where he wouldn't have asked them then because he was concerned about his state? Why aren't those two pretty important things for the jury to have considered, or at least let the trial judge evaluate the testimony?
To the first part about whether or not, this is in conflict with his testimony, and opposing counsel even recognized this, it was kind of unclear based on the doctor's testimony about how he got these keys. And he might have gotten them by stealing the keys. And here the letter just mentions he had keys to every dwelling, but it doesn't create new evidence that he may not have received those letters from them being stolen. But then the question becomes...
Wait a second. Let me just make sure. He had keys to every dwelling. Mm-hmm. So you're saying now that might mean that he stole the keys to every dwelling?
That's what the doctor testified to at trial.
But that's... So it's not clear, but is he entitled to an evidentiary hearing so that the judge can evaluate the credibility? And if this is simply buyer's remorse, that what he said at trial was the truth, what he's now saying is because he feels badly that the guy gets a 10-year sentence, the judge can evaluate that.
Here he received an evidentiary hearing, and it's on page 110 of the first volume of the record. The judge opens up the hearing by saying, we're here on a motion for new trial. And if I don't grant the motion, we're going to move forward to sentencing. At that point, he says, I have this letter, I'm going to make the letter part of the record. Opposing counsel doesn't offer any witnesses in support of their position here. He didn't call the doctor to testify here. All he did was he wanted to, or defense counsel below, sorry, was relying on the letter to be the new evidence. And that was their argument. And the trial court says, looking at this letter, I find it to be immaterial.
I know, and that's, he says, so he didn't agree. The trial court's order denying the motion for new trial recognized the court was denying an evidentiary hearing, having reviewed the letter and finding that his testimony, should it be consistent with the content of his letter, would fall short of satisfying the standard of newly discovered evidence. But he doesn't evaluate, so he's saying it wouldn't have mattered, and maybe in an evidentiary hearing you need to decide, maybe the judge is prejudging it, that it's maybe significant impeachment of this witness, and the jury is entitled to look at.
Well, even if it was impeachment, there are certainly other factors we can look at in determining if this was actually material to the trial. And here, because the letter didn't speak to any element of the actual offense, at best it could be considered a credibility attack on the victim of the offense. But now it's the victim saying that he had consent, even though at trial the defense was necessity. I didn't have consent, I had to do that. And so really when we're evaluating the materiality of this new potential consent to go in, it does not change whether or not he had consent to steal the firearms and to arm himself and then to ultimately sell one of the firearms for, I think it was $300. And so the letter...
Judge Makar says it was twofold defense. First, that the doctor had effectively given him consent. Was consent one of his defenses?
One of his defenses, yes, Your Honor.
Okay, so it seems to me... If I have an employee that becomes close to me and I give them keys and I have this different relationship versus somebody that steals my keys, and he could have, it changes what I might think as a juror. I mean, at least somebody needs to be given the opportunity to evaluate the doctor to see if he is simply reaffirming his trial testimony, or if he's now saying, listen, I do remember that I talked to him about the rage I was in. I was a crazy person as I was going through this divorce, and the defendant knew it. It could be significant.
But having the keys, even if we assume truth, having the keys, even though it was to the dwelling, to the structure, let's say, even though he broke into the structure and that he may have had some sort of implied consent to break this lock on a storage unit, when he entered with the intent to steal these firearms, there's nothing in this letter that changes whether or not he had consent to take them.
I thought it said about whether he actually, whether someone else sold them, whether he had just taken them. So, I mean, again, without looking at this whole trial, I don't know if he benefited and what the victim is saying. Listen, if he really wanted to get money, if he needed money, there was a lot of jewelry in these residences. He could have taken a lot of other things from me that would have been of far more value.
Even if it spoke to the necessity defense, certainly the imminency factor would have not been here, the element of imminency, and whether or not there was not another reasonable means. And that's where the state, in its closing argument and in its argument below, really hung its hat, was that even if he has consent to come in here and to take these, there was no reason for him to do this. It was not, in looking at the necessity defense, a necessity, it was not imminent. There were other reasonable ways, and that's what the state was arguing to the jury, was that there were other options for Mr. Koo here to be able to effectuate his own safety. He didn't need to take the guns and potentially sell one of the guns.
Well, he could go down the street and not come back.
Exactly. Call the police. And he said he didn't feel like the police would help, I believe was the testimony at trial, but certainly committing an armed, what is, for all intents and purposes, an armed burglary to protect yourself and then hiding some of these guns in a lumber yard, which is what the record bears out, it's certainly not the safest way to protect anybody, let alone your own safety.
But didn't he give him the guns back the next day?
He did, which the state argued undermined the necessity defense, because it's clearly he did not feel safe if he rode to the storage unit and gave the guns back the next day. The issue at trial was not necessarily whether or not he took the guns, it really was whether or not this was a necessity. And this does not change, and the letter even contradicts itself in places where the doctor goes on to say he might have been protecting me from my own self, however, of course I would never harm my wife or anybody else. So it seems like...
He's not going to admit, and I mean, again, we don't know, this is, again, and maybe if the problem is, if the issue was it's not an affidavit under oath and therefore it can't qualify, that would be a different issue. So we're kind of, there maybe have been a reason for them to have just PCA'd this, with deciding that it wasn't, since it wasn't under oath, doesn't meet the standard. But we're dealing with it as if somebody evaluated the letter as the judge did, and this is it's sort of an unusual crime. I mean, as I'm hearing this, that you kind of do question the motive, and that context may have helped the jury decide to exercise its pardon power. But seriously, to really give context that this really wasn't. This guy wasn't guilty of the crime that the state charged him with because of what the victim had to say.
Could I ask you a question about whether the trial court ever said that the trial court was denying an evidentiary hearing?
That does not appear in the record, Your Honor, or at least I can't find a place in the record where it would say we're not going to allow an evidentiary hearing on this issue. And it appears that the defense just chose not to call Mr. Koo as a witness, and it might be perhaps because of the unusual facts in this case. And even when we look at the trial transcript from Mr. Koo, the state only called him to essentially ask, or not Mr. Koo, the victim, 3 questions. It said, did he have consent to enter? No. Is the appellant the one who took your guns? Yes. Is this your firearm? We'll enter it into evidence. Is this your AK-47? And that's all the state wanted from this victim in the case. It wasn't until cross-examination where the defense tries to elicit more of the facts of this testimony. And I think maybe that could be potentially part of the reason that that the defense didn't choose to call this witness, because we don't know what's coming out of his mouth half the time. But the trial court took into consideration the letter. And even if it determined that based on the original testimony and this apparently conflicting, where it may conflict, what the trial court really said is this is just immaterial. Even if it might...
But in the aspects of this letter that the defendant is bringing to the court, did the doctor actually say in his trial testimony that he never discussed with Mr. Koo his volatility and problems with his wife.
I don't recall if the doctor did. I know that it came out in trial, and I can't recall off the top of my head if it was Mr. Koo who testified that there was this divorce going on.
Well, I know Mr. Koo did.
Yeah.
I'm saying, did the doctor deny that?
I don't recall that he did. I don't recall that it was asked, though.
Okay.
Yeah.
And so, did the doctor in his trial testimony, because he thinks that the part of the letter about the keys was very important, did the doctor say that he never had any keys?
He said that if he had, I think the ultimate way it came out was that if he had the keys, it would have been because he had stolen the keys and he steals things from me. And that was in reference to the keys to the dwelling. It doesn't seem like there was any conflict in the testimony about him breaking the lock and not having the key.
That's a pretty, saying, that's not what he says in the letter. I mean, he says in the letter he had keys to my dwelling. He could have taken something else. I mean, if the issue is, well, he still is saying he stole them, we don't know. I mean, that's why an evidentiary hearing would flesh this out. Now,
but the letter doesn't say I gave him keys to my dwelling.
Exactly. It just says he had keys.
He had keys to my dwelling.
Exactly.
And I thought there was one other aspect of this that the defense says is very important. And did Mr. Or I guess, was the doctor asked about the selling of the gun? And what did the doctor's testimony?
He said that he needed to give the appellant $300 to retrieve one of the firearms, which he still, throughout the pendency of this, never received that. I think it was the fourth gun. And there was even some discrepancy about how many guns, because it might have been a BB gun. It was, there were several guns that were taken, and he still alleged throughout the entire trial he never received the last gun. And it seems like even though the guns were returned the following day, he still was trying to give this $300. Didn't report this to the police for a month until, for whatever reason, I'm going to assume another falling out between the two, he felt it necessary to finally report this to police. But it did come out at trial that he sold one of the guns, and then he still didn't have one of the guns back.
It seems like the doctor was conflicted in the original trial because he said, when asked on November 14th, did you and the defendant, Mr. Leonard Koo, put guns in the storage unit? He said, I love you, man, but I'm going to have to go with the truth. So it seems as if by that testimony, he didn't really want to implicate it.
Exactly, and he even says it again on page 185 of the record. He says, I loved Leonard, I wanted him to do well. The doctor was really conflicted by the fact that this case had to go to trial, and it seems that maybe he didn't know that there was a 10-year mandatory minimum coming Mr. Koo's way if he was found guilty, and that was this offer of mitigation afterwards.
How long after the actual trial and sentencing was this letter written?
It was a month prior to sentencing. I can tell you when the trial occurred. July 24th, and the letter would have been received in September 2nd, I believe. And then it was entered into evidence on October 2nd at the hearing. So, for these reasons, this state requests this court affirm the decision below. Thank you.
You're out of time, Counselor, but I'll give you about 3 minutes.
What I would like the court to consider is what an evidentiary hearing regarding what is meant by this letter would do to a jury if a jury had the opportunity to hear that, and what reasonable doubt that would create in the jury's minds that Mr. Koo was culpable of a criminal offense for this matter, as this court recently described in its Brooks decision. That's the touchstone. Whether reasonable doubt would be created, that's the touchstone of the probability of an acquittal upon retrial. We can't quite get there until we have an evidentiary hearing to flesh this out. Thank you very much.
What is really your response to I keep hearing over and over during this argument that the defendant didn't really request a hearing, that they appeared, that there was a time set for consideration of this motion, and just didn't ask the trial judge for an evidentiary hearing. How does one hold a trial judge in error if the trial judge has never asked for the evidentiary hearing?
The trial judge was asked for an evidentiary hearing in the amended motion for new trial in at least 3 places, and it's at pages 7.
And did defense counsel have a witness to put on during whatever the hearing was that the trial judge granted?
Defense counsel did not
how-
call Dr. Soleil.
How do you
Because,
deal with this?
because the trial judge is ultimately the one in charge of assessing the credibility of what this letter
Well, this
means.
is not even admissible in evidence. I mean, come on, you've been...
But that's not the standard. Judge, if you look at the cases,
In
whether it's...
questions as to newly discovered evidence, certainly just rumbling pieces of paper floating around are not directly admissible in an evidentiary hearing.
No, but that's why an evidentiary hearing was necessary. The trial judge assessed the credibility of Dr. Soleil's letter without an evidentiary hearing. And this court in McClin and that entire line of cases, as well as the DCAs, say you need an evidentiary hearing if you're going to size up the credibility, unless it adds nothing new and therefore is immaterial, or it is clearly immaterial to anything at issue in the trial, or in the words of the first DCA, the assertions are inherently incredible. And as Judge Makar said, these contentions in Dr. Soleil's letter are none of those. Thank you. I'd ask the court to quash.
Thank you for your arguments. And the last case of the day is Williams v. State.